Hello everyone, welcome to Cashcroft TV. My name is Kalen Ashcroft. Thanks for watching this video on Guide to Legal History and Historians, where we will be covering the authors of the Oxford Handbook of Legal History, edited by Marcus D. Dubber and Christopher Tomlins. So if this is your first video, essentially we'll be going through chapter by chapter, so this is an aggregation of many different legal historians and their respective chapters, so I'll be doing 2x2s, so therefore it's going to be sort of like a Plutarch's Lives, and we'll compare each two. They aren't necessarily ordered in a way that they're particularly well to contrast, or there's a lot of comparisons between the two, but rather just because they're organized in that way. And furthermore, as I always mention, although I have asked for permission to make these videos, it is allowed. However, I have not been endorsed or vetted by the Oxford University Press or either of the editors or any of the writers of any of the chapters. So today we will be covering Assaf Lekovsky and Joshua Getzler and their respective chapters, the Intellectual History of Law and Legal History as Doctrinal History. These are both in Part 2, Approaches Conceptualizing Legal History. So I hope you enjoy these. I think these are particularly two very, very fascinating chapters for me. So yeah, without further ado, we will begin with Assaf Lekovsky. So as mentioned, this chapter is in Part 2, Approaches Conceptualizing Legal History. The chapter is called The Intellectual History of Law. A little background information about Assaf Lekovsky. He is the Daniel Rubinstein Professor of Comparative Law and Jurisprudence at Tel Aviv University Buckman Faculty of Law. He received his Bachelor of Law from Tel Aviv University Faculty of Law, where he was magna cum laude in 1992. He also, from Tel Aviv University School of History, received his Master of Arts, where he received summa cum laude in 1993. And he received his Doctorate of Judicial Studies from Harvard Law School in 1997. He's the author of Law and Identity in Mandate Palestine by the University of North Carolina Press, published in 2006, as well as the author of Tax, Law, and Social Norms in Mandatory Palestine and Israel, published by the Cambridge University Press in 2017. He has been a visiting professor at Yeshiva University, University of Toronto, University of California, Los Angeles, Georgetown University, and University of Bordeaux. He was a Fulbright and Rothschild Fellow at Tel Aviv, and a Golub Fellow at NYU, and a Fellow at the Institute for Advanced Studies in Jerusalem. He's co-founder of the Israeli Legal History Association, and he was the former director of the Tel Aviv University Segla Center for Interdisciplinary Research of the Law, and as well formerly the director of the Tel Aviv University David Berg Foundation for Law and History. And he is also the formerly the Associate Dean for Research at Tel Aviv University, Faculty of Law. So his chapter is called The Intellectual History of Law. Once again, in Part 2 of the textbook, Approaches Conceptualizing Legal History. So in his introduction, he's obviously firstly thanks Joseph Malley, Nader Hakim, and participants of the 2017 Tel Aviv University Oxford Handbook Workshop and for their suggestions. As well, he thanks Katarzyna Sirwagora for her assistance with German sources, and Amanda Dale for her editorial assistance. So he opens up the chapter with this quotation, by himself, of course. Intellectual historians of law are interested in the history of legal ideas and concepts. It says that they are embodied in legal doctrines or found in theories by scholars in academic institutions. He's also interested in history of legal, doctrinal history is, intellectual history is also interested in history of legal education and the production of materials. So when I think of intellectual history, I think of studying of the development of the intellectual category itself. Furthermore, it tracks changes in abstract structures that underlie discourse, as well as the history of legal consciousness and the study of ideas of laypersons on law and institutions. So it's how have laypersons as well grown up in and changed throughout time in terms of their intellectual knowledge of history. They provide casual explanations for appearances and disappearances of ideas and the trace influences over time. This is all intellectual history of the law. The key is to defamiliarize current ideas and concepts about what law is, and this is the first step in the process of reforming them. So by deconstructing the intellectual history of law, we can actually hopefully have a sort of positive approach and therefore perhaps reform laws through engaging in this study, therefore making this an important area of study. So in this chapter, he discusses 10 historiographical trends he believes characterize many recent works written by intellectual historians of law, and as well as the directions of future research that later he will also guide the directions of future research that shall be pursued in the coming decades. He focuses mainly on historians dealing with Western law and the modern era. However, there will also cover some works on non-Western systems and pre-modern periods. Furthermore, the notion of trends, one might criticize the notion of trends or the number that he chose, 10. These might be subject to critique. However, the intellectual history of law is too large of a body of knowledge, so it has to be broken down, and as well, and it has existed in many forms existing in the past. That is history, intellectual history, and intellectual history of law. So it has existed for a long time and broad in scope. So therefore, it's kind of necessary to break it down into some categories. And like any historiographical critic, the chapters will by definition be an inaccurate 10 trends. However, and as well, some may overlap and some could be divided into some categories. However, he chose the number 10 as a convenient scaffolding. I kind of think of the 10 Commandments. There's a comedian, I can't remember who, but he made a joke that the 10 Commandments were chosen to be 10 because it would be a good marketing ploy. Obviously, that probably wasn't true, but 10 does. The 10 Commandments probably could have been 11, probably could have been 9, but 10 just fits better and is easier perhaps to memorize as well. So in terms of the first 5, they are general historiographical trends and implications for intellectual history of law, and then numbers 6 through 10 are more specific to intellectual history of law and their relevance to intellectual history and the law more generally. So, more specifically. So, without further ado, we'll start with number 1, the first of his 10 commandments of the trends that are existing amongst intellectual historians of the law. So that pertaining to space. So over the last around 20 years, the last 2 decades, many historians and legal historians and some intellectual historians of law have become interested in expanding the spatial frameworks used to study the past. The 19th century historiography was linked to the nation-state and its institutions, and the same was true for legal historians. For example, students of ancient or medieval law and religious systems, canon law, Islamic, Jewish law, often used transnational frameworks. Yet many of the 19th and 20th century focused on national legal systems. So it seemed to be it went from a broader groups to a more nation-focused in the 19th century, or the 19th to 20th century. However, as you note, all of these some are re-emerging, so once again it is expanding. So unlike perhaps the universe that has been continuously expanding, it has expanded and contracted, and once again it seems to be expanding. The positivist definition is that laws or norms are produced by the sovereign, and they kept they kept their works within their boundaries. So they focused a lot on the sovereigns, kind of once again like a top-down approach, kind of almost like a political approach. However, recently a series of interrelated turns to global, transnational, comparative, and colonial / post-colonial historiography have revolutionized this intellectual history of law. And scholars of intellectual history of law have also been heavily influenced by these trends. Relating to the second trend, he doesn't go in order because he mentions global, transnational, comparative, then colonial, post-colonial, but starting with the transnational trend. So there have been what's called legal transplants, where some have sought to seek answers of comparative or taxonomic questions, and some require intellectual history of law. For example, the influence of legal thinkers in one era to another. Furthermore, what's called mutual influence, or the interactions, which requires a third influence, has also necessitated the bringing in of the intellectual history of law. Furthermore, broad regions such as European legal thought have broadened the space of the intellectual history of law. So rather than focusing just on nations, we are focused, for example, with the growth of the European Union, focused on more transnational approach. Then to his global cause, the Duncan Kennedy says that calls the three globalizations, in his three globalizations article, looks at Western metropolitan centers' development influence on other jurisdictions. So globalization has actually, although it might have been driven by the center, has also caused a growth in the space of the intellectual history of the law. Furthermore, there's been study in the parallel development in peripheries and metropoles, and as well the codification of English law in India, for example, or the African colonies, which have, for example, the English colonies in India have actually had effects as well on the United Kingdom as well. So there's been a reciprocal effect. So not just driven by the metropoles, but also from the periphery. A very fascinating book for me is by Michael Doyle called Empires, where he breaks down really what is the periphery and what is the metropole. It's a great suggested reading. Furthermore, although there has been globalization, it has been once again decentralized, therefore expanding the space of intellectual history of law. And then to the colonial / post-colonial, as we've seen in some of the previous lectures, there's been more study into post-colonial law, which has once again expanded the space of the intellectual history of law. So not just looking after, for example, the American Revolution, looking before that, once again broadening the space. However, less is known, and there are many questions still necessary, so there's still a lot to be done in this realm of the space of the intellectual history of law. Moving to his second trend in terms of driving that have been common in the intellectual history of law, that pertaining to time. So spatial changes have been accompanied by temporal expansion, he says, in the recent decades. In the mid-20th century, historiography was dominated by social history, where they focused on changes in entities, for example, society, social classes, and the family over centuries rather than decades. So in the mid-20th century, the frame of time was larger. However, and this was especially evident in work of the mid-20th century Annalist school, where they focused on what's called the longue durée, which in French, in English, means long duration, as you most likely would be able to guess. And in the 1970s, there was a broad temporal frameworks started to lose their appeal, so it started to get more focused in terms of time scope. Many historians at this time shifted to microhistory and focusing on singular events, anecdotes, and biographies, and particularly even biographies of ordinary people. Quantitative analysis and large data sets also went out of fashion at this time, according to the author. Recent years, however, there's been a revival of the longue durée. For example, Joe Goldie and David Armitage's History Manifesto, published in 2014, covers a large scope of time, particularly compared to the previous historians. And there's been a call for the return of the history of ideas and the longue durée, like Arthur Lovejoy's work, and Baron M. McMahon. So there's been, once again, an expansion of time. So similar with space, it seemed to have been broader, and then it's shrunk, and then it's broadened again. And once again, he says they're kind of in parallel. And I bet they've been causing, or they had been affecting each other. And then in the 19th centuries, two millennium, Henry Summer Maine, for example, William Henry Summer Maine's Ancient Law, its connection with the early history of society and its relation to modern ideas, published in 1861, was an example of one that was broader in scope. Furthermore, someone like Marcus D. Dubber, who's one of the editors of this textbook, his Legal History Manifesto, inspired by Goldie and Armitage's, calls for a new historical jurisprudence, which is both broad in space and time. So once again, clarifying that there has once again an expansion in space and time. More sources and codes, religions, and more have led to significant findings as well. Once again, I would say that was more on the space-time, but it has also affected time as well. So studying religions over a longer scope of time, and as well codes, for example, over a longer scope of time. His third cause or trend underlying intellectual history of law is that relating to political relevance. So spatial and temporal have been connected with a deep political relevance in legal history. For example, Goldie and Armitage's work to address this would undo the irrelevant work of the 1970s. So it's necessary to have a political appeal of this research. So, for example, when it went into like micro-focus or focusing on anecdotes or specific biographies of even unknown people, it lost its political relevance. Once again, Marcus Dubber's work too also called for the pursuit of topics with normative and publicly significant implications. For example, also in Kennedy's 3 globalizations, as thesis mentioned previously, the goal was to enable progressive elites in periphery to resist a neoliberal hegemony. But nonetheless, there's been a drive in terms of a political appeal in this area of research. There's also been a theme in Christopher Tomlin's, who's the other editor of the Oxford Handbook of Legal History, to be operational, or in his Be Operational or Disappear, published in 2016, which, as the name alludes to, if it's not operational or perhaps not political, it might as well disappear. Often these political notions have been liberal, particularly in the 1970s and 1980s, and in the longue durée of American critical legal studies scholars. But Katerina Isabel Schmid has noted this. But in the big legal history may be retrograde. For example, in the 19th century German historical school, or offshoots of the US and UK have been used to buttress nationalist or colonial or racist ideas. So looking for this political aspect might be what he calls a double-edged sword. Or for example, likening liberty or democracy to some of these historical offshoots or historical 19th century German school. And therefore the desire to make legal history political could be, as I said, a double-edged sword. The fourth trend underlying changes in legal political history would be, the fifth, beyond traditional sources. This is the fourth. Sometimes newly discovered, or sometimes existing so there's been a move beyond the traditional sources, as has been kind of alluded to already. Sometimes they've been newly discovered sources, but sometimes these have been existing sources put to new use or newly discovered. And as mentioned previously, this can often be very cyclical. For example, moving from elite to a non-elite text. For example, American legal historians have moved from a focus on appellate decisions to lower ones in the mid-20th century, and they returned to the focus on appellate decisions in the 1970s with critical legal studies. So cyclical nature, expanding and contracting the traditional sources, use of traditional sources. But it seems on this we're on an expansion trend in this area as well. Sometimes it has gone sideways. For example, the recent issue of the Journal of Critical Analysis of Law, devoted to arts and aesthetics in legal history, and in the 19th century English novels as a source of debtors' prison history, for example, or the 19th century impression paintings to study changing attitudes to pollution and environmental regulation. So expanding to traditional, I would also say this kind of falls under, as you said, there's overlap in terms of these categories, but in terms of space, if you're looking at art and aesthetics, as mentioned in this journal article, for example, English novels, or example, Impressionist paintings, which I think is particularly interesting. If you look at Impressionist paintings and they draw, for example, a polluting factory, which is a common thing to say, it was with like a dark sky and evidently showing a growing negative attitude towards this. So that's sort of a sideways movement in terms of traditional sources. The literary study to study the rise or fall of a genre. For example, you can read Simon Stern's literary analysis of the law, which is I covered previously, and he very, very fascinating, but sees how, for example, words can come out in and out of popularity, and you could use data analysis to elucidate this. Moving to the fifth, the digital revolution. So for the last few decades, has changed the nature of history research. Digital revolution has changed the nature of historical research. For example, mass scanning of books and archival resources, and the growing use in big data to study the past, and development of tools to mine data. For example, Google Ngrams to allow quick searches, reducing sometimes searches that would take up to months in just seconds in some cases. So the digital revolution has clearly changed the research of intellectual history of the law. Furthermore, legal records were some of the earliest records to be digitized, so perhaps unlike other fields, the law is actually particularly ripe for this area of research because legal texts were some of the first to be digitized and some of the first documents generally to be written. Often this does not lead to new questions or arguments, however it has helped in illustrating them. Some of the more promising, he says, some of the more promising projects are the modest ones. For example, databases on law professors of the past, or visualization as well of certain concepts. For example, what I'm creating here could be seen as a database on the legal historians that I am covering. For example, or furthermore, new teaching tools that could be used by these professors to make easier links between resources as well. So some of the more modest proposals in the digital revolution could actually have a very big impact on the intellectual history of the law because people could just learn better in modern times. Moving to the sixth, actors. The first part, individuals, communities, and networks of knowledge. So he said, in the past, intellectual history, in history of the natural sciences, social sciences, or humanities, often used the biographical approach. This was from the Romantic era notion of individual genius, perhaps, and they sought to reconstruct through the great minds of the time, and it was kind of seen as sort of a baton race of great minds. However, in the 1960s and 1970s, there's been a shift from individuals to communities of knowledge. Some of the milestones in this front, for example, would be Thomas Kuhn's The Structure of the Scientific Revolution, published in 1962. Michael Foucault's The Order of Things, published in 1966, the French version, and it led to the sociological accounts of academic communities in the following decades. So going back to the previous video on the social history of the law, there's been the social history would probably be considered a top-down approach, as contrast the political approach, which would be, social or cultural would be a bottom-up approach, political would be a top-down. So political would be like looking at the top minds and sort of the baton race, but then from like Michael Foucault, a bottom-up cultural history approach. So a change in the actors. Furthermore, this has been strengthened by linguistic and cultural turns in historiography. Sometimes elite groups, for example, the Republic of Letters or the historic Cambridge School, have kind of contrasted this by focusing on the key actors. Sometimes broader, the French historic des mentalités approach, which is focusing on the changes of mind, has once again expanded the scope. Going back to Kuhn's example, he was inspired by critical legal studies scholars in 1970s and 1980s to expand the scope of, or expand those who are considered leading actors in this realm. But once again, he notes it's a spectrum from individual to communities, and it's and there's a need perhaps for both. But it does seem to be a trend towards a more focusing on at least more individuals. For example, juxtapositions could be of significant value, for example, even in the binary. For example, looking at a biography of Hitler or looking at a biography of Stalin might be great, but looking at Alan Bullock's Hitler and Stalin Parallel Lives might be of greater merit, he said, which is essentially exactly what I've been doing here, where I covered two at a time, which, although it might have been better to focus on one, and that's it, but by doing the comparison, at least I learned better, and it might be of greater actual overall merit, or at least I might be contributing something. In terms of the focus on major intellectual history of political thought, this has been led by often what's called the Cambridge School, and for example, where they focused on someone like Henry Maine has been more studied than Sheldon Amos, who's been more studied than the colonials, William Markaby, William Henry Ruttigan, or Frederick Goodby. But that does not necessarily mean the latter are less needing of serious study in the intellectual history of law. Moving to the seventh trend is the actors to concepts. So the linguistic term of and contextualist approach has been related to the rise in conceptual history, the study of keywords, for example, honor and liberty, over an extended period of time. In the German-speaking world, the main advocates in the middle to late 20th century were historians like Reinhard Koselleck. In Anglo-American world, the Cambridge School, led by Quentin Skinner and J.G.A. Pollock, and some pioneering cultural studies researchers such as Raymond Williams have also led this trend in terms of change in concepts. Today, conceptual history as a flourishing subfield of intellectual history. For example, the journal Contributions to the History of Concepts. Some focus on emotional concepts, for example, in social cultural history, but mostly have been related to key political concepts such as citizenship or liberalism, and to make them, once again, going back to the political notion, is to make it more relevant and attract a better, larger audience, and sometimes, as mentioned previously in previous videos, it could be a way to attain power in the academic community or funding. Often they pursue lexicographical projects with large group of collaborating scholars. For example, in the German world, there's the Dictionary of Historical Political Terms called the Geschichtsschle Gundergriff, pardon me, my German is not too good, but I am studying every day, or the Legal Terms Dictionary, Deutsch Rechtswörterbuch. So they have these two large dictionaries which are, in a way, expanding concepts. But he does suggest there's a need for similar projects in the Anglo-American world, focusing on legal keywords. Furthermore, also collaborative projects in key legal concepts are comparatively needed in the West and globally. So there have been an expansion of concepts led by lexicographical trends. However, he says it's been perhaps stronger in Germany or in some European countries, but it needs to be more utilized in Anglo-American or Anglo societies. Moving to the 8th trend, he has sites of knowledge, production and dissemination. So the traditional intellectual historians studied relatively few canonical texts by relatively few elite thinkers. Here's a quote from him. There's been the paradigmatic example, history of philosophy of a type of introductory course based on a linear chronological series of leading texts imagined as being a dialogue with each other. But intellectual historians today, however, are interested more in such things as canonical texts, so expanding the scope of the sites of knowledge to canonical texts, for example, and the context they emerge from, so even expanding in that too. Once again, there's overlap. Once again, I would say this is space, but also time as well. There's also been further look at non-academic sites, and a look at the way material is inseminated in the public or to private non-legal individuals. Some of the issues, however, have been translation, censorship, and a history of law of print and plagiarism. So, for example, some things might have been destroyed over time, some things might have been censored over time, some things just might have been forgotten over time. So, although there has been efforts to get more from these sites, a lot has perhaps been lost. But all have been, or he says, have been studied well, but perhaps there's a limit to how well it can be done. Religion, he says, specifically is a key site that is worthy of more study and seems to be a trend. For example, the Talmudic academic works, which were recently discovered, have blended leading insights into Jewish law studies, as well the personae of legal scholars, what makes a proper or exemplary scholar given their place and time, so taking more into the context or studying more about the sites of knowledge. So who was the writer? Were they good? Were they good relative to their time? And furthermore, more research in legal consciousness. For example, how was information and what did laypersons know? Where, and for example, where were furthermore, in terms of where were the sites, was legal information spread through coffee houses, theaters, beer houses? What were the sites of the intellectual history? How was it transferred, particularly to laypersons? And it's all bridges on the gap of the intersection of social, cultural, and intellectual history. To the 9th, beyond traditional legal fields. So historians of science no longer are interested in science exclusively, for example, or paradigmatic fields like physics or chemistry. So scientists have taken a more broader approach. Now more attention to marginal areas like those of the social sciences. So once again, science bridging onto social sciences. So he says fewer people are just physicists, but now you might have a scientist who's also into anthropology. A related process has also been for example, the word Western science and the word non-Western science has expanded into the history of knowledge. The same has been true in legal history. For example, the move beyond the core sources, for example, constitutional, contract, tort, or criminal law, to less explored international law, tax law, or intellectual property law. Often it's been doctrinal, economic, or social history, but it's been increasingly led by intellectual history. For example, intellectual history of international law explores works of early modern scholars who shaped the field. So once again, if you're still unsure what intellectual history is, it's studying often who the scholars were, or how did they shape the field over time. Some unexplored by intellectual history are the conflict of laws, and I think in my current work, for example, alignment of laws is a very common thing. For example, you might compare a First Nations treaty or their treaty rights with the UNDRIP, United Nations Declaration of Indigenous Persons, and you might compare the alignment of law, so therefore the conflict of laws. So this is once again moving beyond the traditional legal fields into some less common fields. But still much progress is needed. For example, more focus, he says, needs to be made on non-elite, non-Western, and non-academic legal fields. And then lastly, to the 10th trend he sees in the intellectual history of law, exploring law's boundaries. So one major factor that has driven the study of legal histories is the willingness to expand definitions beyond the traditional positivist definition. So positivist, my apologies, I had thought positivist was to I don't know, take a positive approach, but it's more just something that is provable. So they've moved beyond the traditional positivist definitions to more fluid, like other social sciences. For example, it's called the Hurstian Revolution in American legal history, was based on the willingness to define law beyond doctrines and hierarchies to rules of lower jurisdictions, for example, state legislatures and its administrative agencies. So the boundary of the law had shifted during the Hurstian Revolution. Similarly, in the last decade, much of interesting work produced by legal history was inspired by rejection of state-based positivist definitions of legal law in favor of non-state and legal pluralistic notions of litigation. So just by expanding with the scope of the law and taking a less of a positivist approach has expanded the boundaries. Therefore, an interest in boundary work, for example, where does intellectual history bound by sociology, anthropology, and the STEM science, technology, engineering, and mechanics, I'm not sure. The intellectual history and science, for example, studies how it differs from magic, technology, or religion over time. So, for example, intellectual history of the law might compare how it contrasts with STEM over time, or how it contrasts with sociology over time. However, they need more critical, external, non-evolutionary, and non-celebratory works to be explored. So it's been focusing on the most important works, even at the boundaries. So those are the 10 trends that have been affecting or have been most written about as he observed in the intellectual history of the law. And then he moves on to his conclusion, and he says that many of the trends are not new but have been cyclical, noted. For example, big legal history on the longue durée was not new. For example, Henry Main's work already existed. It just temporarily contracted for a time and now has expanded again. Others, such as the digital revolution, is essentially novel because it's just been expanding over time. He's a bit skeptical or cynical in the discipline, but it can be a risk for those who are skeptical or cynical in the discipline. They run the risk of being naive. So don't be cynical or skeptical, because it could just be naive. You might be missing opportunities. A major avenue is the coalescence of various national legal history communities engaged in comparative transnational studies, both in Western and non-Western systems. So, and many of these trends have evidence that this is happening, but further, he hopes this continues. So, I will move to the slide, then we will move to the next section by Joshua Getzler, pardon me, and then we will move to comparison, so we'll discuss them a bit more shortly. So in the top, so this is part 2, Approaches Conceptualizing Legal History, chapter 9, The Intellectual History of Law by Assaf Lekovsky. The top right, we have the Buckman Faculty of Law logo from Tel Aviv University. Below that, to the left, we have the new logo of the Harvard Law School, which was actually not the logo when I was there when he did his doctorate of judicial studies. However, that is the new logo. To the right, we have the symbol of the Georgetown University Law Center. Below that, we have the symbol of the University of California, Los Angeles School of Law logo. Below that, we have the logo of the University of Toronto, and below that, we have Cardozo Law School. All law schools he has had affiliations with, and some of which he has taught at, or all of which he has taught at. His institution, the Buckman Faculty of Law, Tel Aviv University, position professor of comparative law and jurisprudence, research interests, legal history, taxation, comparative law, and jurisprudence, suggested readings, a colonial legal laboratory, jurisprudential innovation in British India, published by the American Journal of Comparative Law in 2021. It still says forthcoming, but I think it is out, and you may now read it. Tax Law and Social Norms in Mandatory Palestine and Israel, published in New York by the Cambridge University Press in 2017, and Law and Identity in Mandate Palestine, published in Chapel Hill by the University of North Carolina Press in 2006. The top quote is, "Intellectual historians of law are interested in the history of legal ideas." Below that, we have the 10, in this work I discussed, 10 historical trends that I believe characterize many recent works in intellectual histories, and to repeat them again are 1. Frameworks, 1. Space, 2. Frameworks, 2. Time, 3. Political relevance, 4. Beyond traditional sources, 5. Digital revolution, 6. Actors, 1. Individuals, communities, and networks of knowledge, 7. Actors, 2. Concepts, 8. Sites of knowledge, production, and dissemination, 9. Beyond traditional legal fields, and 10. Exploring law's boundaries. So next we will move on to the chapter by Joshua Getzler. So this chapter I really enjoyed. It was really got down into some of the more nitty-gritty history stuff. So if you are just tuning in now, I hope you enjoy this part as well, particularly as much as I did. So a little bit about Joshua Getzler. Part 2. He is a professor of law and legal history at St. Hugh's College at Oxford, and he's been in this position since 1993. He received his first law degree from the Australian National University in Canberra, and his Doctorate of Law from Oxford in both Balliol and Nuffield colleges. His doctoral monograph was on juristic and economic factors governing control of water in historical common law. Currently, he's studying the duties of investment agencies in financial markets. In terms of his research pertaining to current issues are the duties of investment agencies in financial markets, legal and economic structure of securities, liability and ontology of jurisdictional entities, and the theory of trusts. Relating to his the areas of interest relating to historical concepts are fiduciary accountability in private and public relations, and evolution of property, trusts, corporate and charitable forms, principally in the 18th and 19th centuries. He has previously taught and researched as a fellow at the Australian National University and Hebrew University. Additionally, he was a visiting professor at the University of Chicago, Columbia, Penn, and Tel Aviv University. He's also the co-joint professor of law at the University of New South Wales, and in 2023 he will start as a global visiting professor at NYU, New York University School of Law. So his chapter is is in part 2, Approaches Conceptualizing Legal History. His chapter is number 10, legal history as doctrinal history. So in his introduction, he says, how do we account for the rules of law governing particular areas of social life changing over time? That is the question he poses. Scholars debate change reflects internal shifts of view within the profession or external pressure from powerful groups seeking to advance secretarial ideas or interests, or deepen current, or it might be caused by deeper currents of underlying society, such as demographic changes or economic transformations. These accounts are focused on first perspective, or this will account mostly for the perspective of doctrinal history, which relies on the formal materials such as reports or of decisions, texts of statutes and codes, and evidence of lawyers, argumentation and reflection, and therefore to reconstruct the mind of the professional legal mind collected through specific doctrines. In terms of English common law, there's been excellent doctrinal history available on charity, agency, contract, crime, equity, evidence, family law, land, torts, obligations, native title, unjust enrichment, water rights, company law, constitutional law. Some focus zero in on leading causes and write microhistories of changes within these areas, charting incremental changes to doctrine, such as Brian Simpson, a master of this technique, he says, and where he shows the effect to cast, and the effect is that it almost casts an ironic eye on the pretensions of common law and show how arbitrary and obscure doctrine can be. So if you zoom in so much and see how quickly or how frequently they change, it's almost ironic how arbitrary they are. On the other end of the scale, there is impressive survey historians of doctrine over large spaces of times, exhibiting achievements of collectives. For example, William S. Holdsworth's History of English Law, or the New Oxford History of Laws of England. So these are much larger projects discussing the changes of doctrine over time. This chapter will not discuss many fine examples of doctrinal history because there are too many and too large to form unity, even with just if we were just to focus on England, and rather we will make up a major part of the historical writings of common law generally and civilian jurisdiction. So if we were to focus on this, it would just be too large of a topic. Instead, we'll focus on the idea of doctrine as focus of historical scholarship, and how the mentality arose and how it became strong in both common law and civilian/Romanistic legal cultures. He will first define the subject more accurately and set out a guiding thesis. An important dimension and outline an important dimension is communication will be argued, and that jurists become fascinated in history of doctrine when social and political conditions necessitate an expansion or transfer of the legal system with constituent transfers of doctrinal thought. So that's just what the chapter will cover. It'll all make sense very shortly, but I think this will be very fun because we will start from Roman law and see how it has trended into, for example, Germany and in the common law, and as well a little bit of France and England and the United States. So what is doctrine? For lawyers, it expresses authoritative juridical ideas that may direct the course of legal discussions. They can be embodied by positive legal texts, but subject to dynamic interpretation of the community. Therefore, history of reading and speaking is not just of writing. So doctrinal history is not just the specific texts. Lex non scripta focuses on the unwritten norms that command broad assent. No one interpretation, according to Jeremy Bentham's common law has no doctrines, but this has been effortlessly ignored because doctrinal study is a huge area of law. So, although Jeremy Bentham says it's common law has no doctrines, it evidently does, even though there is much lex non scripta. Doctrina Latin, or denotes teachings or communicatable, or doctrina, the word itself is a Latin word, and it denotes the teachings or communicatable knowledge. It is associated as much with law as history of the West, and thereby with theology and moral and political philosophy. Skepticism, pseudo-theology, has an unwarranted claim to wisdom and power. Skeptics say that doctrine has an unwarranted claim to wisdom and power. Worse, it could become an ideology. However, this is not necessarily so don't focus too much on doctrine, because there's subject to a little bit of interpretation at least. The internal viewpoint is that it's congruent with ethical political principles. The immediate task is more prosaic. The roots go back far, and some of the major achievements, some of these doctrinal achievements have been some of the greatest achievements in Western culture, and they are worthy, therefore, of historiography. So the classical origins, starting from Gaius and Justinian. So in the 2nd century Roman jurist, Gaius was one of the great founders of the doctrinal tradition, perhaps the greatest. His book, Institutes, published in 170 AD, is a thematic summary of jurisprudence. It was likely a teaching text used for his stadium, and likely not part of the mainstream casuist lawmaking of the time. Much was made available to scholars from late antiquity through a later reproduction in an edited form in the 6th century legal text codification by Emperor Justinian. However, we can trace its roots back to Gaius, who originally started this doctrinal work, or a great body of doctrinal work. In 1960, an overwritten 5th century copy of complete text was discovered in Verona Cathedral Library, giving a direct access to Gaius, free of editors as well, so it's pretty well now preserved. It's probably the most important law book ever written, he says. It's an achievement because it develops highly rational and original taxonomy of Roman jurisprudence, categorizing various sources of law and dividing substantive and procedural laws subject by subject and showing their relationships as well. He drew from Aristotelian ethics, science, and biology, as well as Ciceronian rhetoric, and filtered through schools' debates of the time. However, there is no real precedent in contribution to legal thought. So although he drew a little bit from Cicero and Aristotle in terms of some areas, there's no real precedent in terms of legal thought, his contribution to legal thought. He classified the terrain of law between law of peoples, loosely the intermediate natural laws, and civil laws of a particular community. So people laws and civil laws. Distinct lawmaking actors as well. There were emperors, officials, jurists, and legislative assemblies, and there was customary law, which is implicit by involuntary conduct of the people. Lex was the spoken or verbal command law, and ius was the normative principles decided by society and not any individual person. Doctrine by skilled jurist interpretation was identified and interpreted by ius and lex. When doctrine officially endorsed by legislation, it became lex. So ius is kind of like the conventions, and lex is the written law. And once it is written, it becomes lex. Private law was divided in 3 divisions. 3 persons who are subject to the law, things or assets or interests claimed of each other, actions, legal methods by which persons asserted status or claimed things. Applied to all the law, all applied to the law, for example, even slaves, women, and children, and or delictual obligations or criminal obligations and remedies for debt and unjust enrichment were also covered. However, they sat uneasily between some of these categories. Succession and inheritance laws, for example, were hybrid of all 3 of these categories. He eschewed more political subjects such as crime and constitutional law, and was morally and politically neutral, therefore, and this later caused it to arouse fascism in future generations, because in Alexis de Tocqueville's On the Old Regime and the French Revolution, he actually says that German law was only civil and had no political elements, and therefore, as we saw many years later, as we'll see later in this chapter as well, led to some fascism. And this is in the notes as well of Alexis's Old Regime and French Revolution, so got to look in the back to find that. He relied on doctrinal history himself, and it was essential classical elements. Sociological knowledge from Greek-speaking Syria and Phoenicia had contact with Judeo-Christian laws and ideas. For example, there were influences of Paul, Ulpian, Papinian, and they made up a greater part later in the Digest of Justinian. However, Gaius really had the largest communication. The Digest of Emperor Justinian later came, and it was produced between 5 years, from 528 to 533 AD, in 50 manageable books, a feat of compression and organization by adapting the materials of the Eastern Empire's law schools, and it culminated in the Corpus Juris in 533 or 538. And it was a mass exercise of historical doctrinal study. So his next chapter, his section is called Doctrinal History from the Eos, Commune to the Codes. So this digest, or pandets in Greek, may have had little effect, however, on Rome because it was fragmenting at the time. But in the 11th century, lawyers in northern Italy, and later in France, Germany, Spain, and England revived the digest, and the institutes from Gaius, and these became the foundations of laws schools in Bologna, Montpellier, Paris, and Oxford. And the concept of university was born from a need for doctrine for lawyers. So it all came from this Roman law. A seminal figure in this was Bartolus Sassoferrato, living from 1331 to 1357, who produced the prestigious Learned Laws, that applied to free cities, principalities, feudal estates, church, and empire in intricate balance, where doctrinal history became a political science. And so it had a lot of prestige with it as well, because it was doctrinal. If it wasn't doctrinal, there would have been nothing to focus on. After Bartolus and the Reformation, lawyers incorporated Romanist laws in local laws in what's called the Reception. The ius commune, or the common legal heritage of Roman doctrine, was divided into national wings through the division of Europe. And international dimension, the natural law, theology, and ethics infused in learned laws by Spanish and Dutch scholars, such as Suarez and Grotius. In post-revolutionary France in 1804, they developed the Civil Code, which was liberalizing, anti-feudal, and based on Gaian taxonomies, and it spread in the wake of Napoleon. And it was an early production of a code prevented the need for further historical doctrinal study. So in 1804, it was done. They made the French Civil Code based on Roman laws, and it was pretty much not much more research was necessary. However, Germany was still open because they did not develop their code until much later, so they continued to research into this. So Germany, by contrast, led by Frederick von Savigny, believed in a deeper study of classical legal doctrines would help Germany build civil culture, but it was elitist attitude focused on nationalism and post-Napoleon period, covering both Roman law and ius commune, as well as native and German customary and municipal laws. So this time German law was kind of split into two groups. There was the Pandectists, who focused on doctrinal history as a staging post of civil law as a unifying project for the German states, led by those such as Bernard Windschied, and as well as driven by the philosophies of Kant and Hegel, their philosophies. On the other hand, there was devotees of Roman native law, such as Otto von Guericke, Henrik Brauner, Louis Brentano, Rudolf Gneist, Andreas Husker, Felix Lichermann, and they paid attention to local norms of the Teutonic peoples and tended to neglect family because they believed that the Roman laws neglected the family and associated public law. So we have the Pandecists, who are really focused on strictly the Roman ideas, and then we have those who are more focused on the sort of German and more cultural aspects. Rudolf Düring in 1818 living from 1818 to 1892, wrote the Ect Panicus, which he switched his to theory of free law over time, so he kind of shows a shift in his beliefs, whereas he said jurisprudence is a tool for social need, and he was a speaker that toured European capitals. He had a double status because he started off as a doctrinal superstar, a panticist, and later became a public figure tinged with rebellion. Then the German Civil Code was established in 1900. It was the fruit of panticism and a guarantor of unity for German, pan-German Bismarckian state. It was more elaborate than the French Code, so it's had a lot more stricter laws, which made it ripe for fascism. Similarly, it was adopted, and this German code was similarly adopted anywhere where the French Code or the English common law had not already taken root. For example, Meiji Japan adopted this, and it spread later through military conquest until much of Asia, such as China. Gaius doctrinal code so therefore the Gaian doctrinal code is very evident through the German doctrinalism as it spread as a common language, lingua franca, and because it was necessary for transnational trade and a blueprint for successful state formation. So Gaius from a long time ago had this large influence, particularly through Germany, and spread all through the East. So that is the one side, the sort of civil law side, and then we have the common law tradition. So from the 1066 conquest to the reigns of the Angevin kings, Henry I and II, in the 12th century, common law developed a unique set of doctrines borrowed from Anglo-Saxon and Norman precedents, and driven by unique position of English crown at the apex of the post-conquest feudal hierarchy. So what happened was the monarch sent out royal jurists to supervise tenants' rights, but it was largely to keep the peace, but also to keep their revenues strong. And they protected these tenants. They protected tenure and formed a core of common law. So if you think of the real root of common law was to protect tenants, common because every freeholder had equal access to the king's court, therefore they could leapfrog intermediate federal jurisdictions. It was cultivated by lawyers with good awareness to Roman doctrines, so there were Roman roots in common law. In the treaties describing the nascent common law and Roman doctrines, such as Glanville, 1188, and Brompton in 1235, perhaps earlier, but they could also be perhaps related to the Visigoth doctrines as well. Few adoption of Roman structural ideas, however, were directly included in the law's substance. It was a much more fluid process. Originally, they were formed from judicial review of subordinate jurisdictions, and then expanded to the entire society as feudal society withered away. So as the feudal lords disappeared, it was just the common law from the freeholders straight to the monarch. Modern common law, emerging in the 17th and 18th centuries, was distinct in that it was pluralistic, and it was substantive rights not authoritatively proclaimed by judge and jurist, but they were secreted through interests in procedure. Until the 19th century, law was not taught through universities, rather it was from self-study, moots, and apprenticeships, and therefore it supplants of Roman doctrinalism. Were somewhat of inoculations because they were just happened to be brought up in the legal profession, but not formally taught in universities. Therefore, law was a tacit or craft. For example, Sir Edward Coke in 1607 defied King James's personal power of judging because he said the law required long study and experience. So although he said, King James, you are very intelligent and you are the monarch, the law requires much study to be able to use it. Sir Matthew Hale and Sir William Blackstone set the foundation for criminal law, and Blackstone, they almost created a doctrinal work. However, Blackstone was more popular with laypersons and in the U.S. for example, James Kent, the Chief Justice Chancellor of New York, and Joseph Story, the Supreme Court Justice of a Supreme Court Justice. Whereas nothing similar in England was established until the end of the century, fin de siècle. But whereas in the U.S. they sought substantive doctrine to take away power from the mute lay jury. For example, they established special juries. So perhaps because the United States was a more equal country at the time, they needed to have more doctrine and therefore more receptive to Blackstone's work. In the 19th century classical period, elites were established through universities. In the 1870s, there was expansion of the British Empire into, for example, Australia, Canada, New Zealand, and South Africa created their own common law systems. So therefore, the United Kingdom saw a necessity of becoming more doctrinal to strengthen their own power. And with Oxford as the epicenter, for example, they saw how to supplement English law in India. Frederick Pollock in 1845 to 1937 and John Salmon of 1862 to 1924 were key figures in establishing the modern doctrinal analysis, the former being from Cambridge and the latter from New Zealand. Romanism influenced some, for example, John Austin in 1790, living from 1790 to 1889. He's considered the founder of modern legal analysis after Bentham, and he's a refraction of Pandecist German Gaianism, or Pandecist Gaianism. And Nathaniel Lindley studied at Bonn, studied in Germany, was a leading company lawyer in the late Victorian period from 1828 to 1921. However, outright systematizing of Pandecism, like Austin and Lindsay, were rare, especially in America. More influential by German, so the Pandecists were less popular, but there was a little bit more of the German Teutonic historical schools, and some of the most gifted flocked to Anglo-Saxon and medieval English law, so over the Roman studies, because it was seen as elitist and prestigious, particularly in America. For example, John Adams, Melville Biglow, Oliver Wendell Holmes Jr., and James Bear Amis, and James Thayer, all focused in the 1870s and 1880s focused on English law rather than Roman law or even Teutonic law, because it was perceived as more prestigious. Like Gierek and Düring, this may have preferred Volksrecht und Gemeinschaft to soften and constrain individualism of American capitalism. So perhaps they preferred the German Teutonic laws over the Roman laws because American capitalism was already very strong because of the large equality in this country. So therefore, because a lot of those laws were more communitarian and based on the shared Teutonic ancestry. Oliver Wendell Holmes, living from 1845 to 1931, considered, according to the author, the greatest jurist from American group. In 1899, wrote, "Some rules are mere survivals. History sets us free, enables us to make up our minds dispassionately. Therefore, doctrinal history is the handmaid of law reform." Frederick William Maitland, living from 1850 to 1906, was from England, who had an expressive style and scholarly acumen comparable to or exceeding the greatest Germans or Americans, according to Joshua Getzler, who was originally a praised Pandecist for his codification. He praised the Pandecists for their codification in 1906 as a model for English reform, and the making of the German Civil Code he praised. But in his 1888 inaugural lectures at Cambridge, he said why history of English law is not written, therefore pushing against having an absolute doctrinal approach. But my question for Joshua Getzler, if I could ever ask him, is that he endorsed the German Civil Code in 1906. However, his inaugural and the year he died, so perhaps he eventually ended up dying as a Pandecist. rather than in 1888 his inaugural address at Cambridge, where he said he advocated for having non-written laws and advocated for common law. New liberalism, fresh moral, political, decoded doctrinal stories of science about expansion and the adopted into something larger. There have been equally, and he closes off the chapter by saying, equally great discoveries for further doctrinal histories are available. One just needs to start looking. So personally, I think doctrinal history is fascinating because it's so tangible, and it really goes into history. It was cool seeing the trend of Germany all the way to the east and even into the United States and into Asia. I think it was absolutely fascinating. So moving to the slide, and then we'll move to the comparison. So this is part 2, Approaches Conceptualizing Legal History, Chapter 10, Legal History as Doctrinal History by Joshua Getzler. The top right logo, we have the logo of Oxford, University of Oxford, Faculty of Law. Below that we have the National University of the Australian National University logo. Below that we have the University of New South Wales, where he's a co-joint professor. And below that we have New York University Law School, where he will begin as a global visiting professor in 2023. His institution, the University of Oxford, Faculty of Law, Professor of Law and Legal History, Research Interests, Modern Legal History, Law and Economics, Obligations, Equity and Trusts, Property Theory, Corporate Theory, Law and Finance, Capital Markets, Law and Religion. The quotes, Doctrine for lawyers expresses authoritative judicial ideas that may direct the course of legal decisions. How do we account for the rules of law governing particular areas of life? And no doubt there are equally great discoveries awaiting future doctrinal historians. One just needs to start decoding. So that's something I would be very fascinated in doing. Suggested readings, Judges and Judging in the History of Common Law and Civil Law. J.S. Getzler and Paul Brand were editors, published by the Cambridge University Press in 2012. Company Charges, Spectrum and Beyond. J.S. Getzler and Jennifer Payne were editors by the Oxford University Press in 2006. And A History of Water Rights at Common Law, published by himself, Oxford University Press in 2006. And these three images, on the far left we have a statue of Gaius. Next to him we have a picture of Justinian, the first emperor of Rome. And to the right of that we have Karl von Savigny, very influential in bringing the Roman law into Germany particularly, and Italy. Particularly Germany, pardon me, and Frederick William Maitland, who he said was perhaps superior to all others of his contemporaries in all nations. So, the comparison between Asaph Lekovsky and Joshua Getzler. So, firstly, Asaph Lekovsky was educated in Israel and the United States. Joshua Getzler was educated in Australia and the United Kingdom. So, just differences. You can take what you want with that. One was focused on, this chapter was Intellectual History of Law, and the other was focused on Doctrinal History. So one was two very, very different areas, but I guess a very common theme was they're both focused on history, and they cover large spaces and times. They both covered huge realms of times. One wrote about compared the long durée and recent decades, so like two scopes of time. However, I would say Joshua Getzler's scope of time was a little bit larger because he started in the very early ADs with Gaius. One focused on 10 trends of intellectual history of the law, whereas Joshua Getzler was more focused on one trend, which was that of doctrinalism, and as it affects to two things, common law versus civil law. But both absolutely fascinating legal historians. I hope you enjoyed this video and continue to support. Thank you so much.